Hello, my name is Alma Robinson, and I am the Executive Director of California Lawyers for the Arts. CLA is a statewide nonprofit organization that was founded in 1974 to serve artists and arts organizations of all disciplines with advocacy as well as services that provide support with legal and business issues. With staffed offices in San Francisco, Berkeley, Sacramento, Los Angeles, and San Diego, we provide several core services. First, we provide legal counseling to specialized attorneys who provide assistance with a variety of intellectual property questions, as well as contract reviews and negotiations, and other important business issues. Depending on the client's financial status, legal assistance may be available on a pro bono or reduced fee basis. We also provide a specialized program that assists independent inventors and small startups with their patent applications. To help with situations involving disputes, we provide a range of alternative services, including negotiations counseling, mediation, and arbitration that can avoid the expense and hassle of going to court. Finally, we offer a full menu of educational programs that include workshops, symposia, and conferences on various legal topics for artists and arts organizations. Many of these programs are posted on our YouTube channel, and we encourage you to use these tools to educate yourself on the legal issues before you reach out for specialized assistance from our organization. Thank you for joining today's program, and please consider joining CLA on our website at www.calawyersforthearts.org so that we can continue to maintain our full range of services. Thank you.
There we go.
And I can do the disclaimer if you'd like.
Yeah, there we go. Perfect. So I'll
Cool.
let you take away with the disclaimer. I'll leave it up for people to read.
Yep. So this is something that we have to do. Part of the reason you all are here is that we're attorneys and we have certain things we've been trained to do and knowledge that we have. And part of what we also have to do is tell you guys that nothing that we say here today is legal advice. Please don't go out and act on any of the things that we outline, describe, talk about today, because they're not actually unique and specific to your circumstances and your facts. And so you want to make sure that you confirm anything that we talk about today with an attorney. We provide free consultations. We're happy to discuss anything more at length that we don't get to today or that we can't sort of talk about specifically for you today. And so at the end of the day, this whole disclaimer just says we're providing informational content only. This is not legal advice. Please don't act on it.
Thanks, Sam. All right. So today we're going to talk about something that we call the 3 lines of defense. There are 3 main areas where you can really protect yourself as a creative business, as a business owner, as a freelancer. These are the 3 kind of basics for anybody. They are well-drafted contracts, insurance policies, and an entity. So we're going to talk about all 3 of those today. So first is contracts. And typically we work with people who have contracts that they've either created themselves or maybe they've cobbled something together that they've gotten off the internet. Usually that's not going to be a good idea. And there are a couple of reasons why we think hiring a lawyer is your best bet. Number 1 is that you don't know what you don't know. And that's okay. You guys are not trained attorneys. You shouldn't have the same sort of knowledge that we have, just like we don't have the same knowledge that you have about various types of arts. So speaking with a lawyer, they're going to be able to help you kind of issue spot and figure out different risks that maybe you weren't aware of, different things that can be included in contracts, and on the flip side of that, things that absolutely should not be in a contract. So that's one main reason why hiring a lawyer is a better idea in most situations than trying to wing it.
I'll chime in real quick on that one too. Just a real world example of something that we've been working on lately for a client. We were working on an agreement for them, and this is a little tidbit of knowledge for y'all out there. You actually aren't allowed in California to require that your clients or customers pay the processing surcharge that you pay with your merchant processor. And so just a great example of something you might not know that you don't know is we had a client that requested we put that specifically into their contract, and we can't because it's illegal.
There's all kinds of things like that. And something that Sam and I often kind of see in our work is A lot of these Facebook groups where people join, they're like affinity groups for different types of industries. They'll share templates and paperwork, and that kind of leads into that second sub bullet right there about online templates. Sometimes those templates are from people that also don't know what they're doing. So it's sort of like the blind leading the blind, and it seems great, but sometimes they're incomplete, they're vague, they're based on outdated law or otherwise have issues. So you can potentially work off of those as a start, but you always want to have attorneys review your end product to make sure that it's good to go. If drafted correctly, your contract terms will generally control sounds like a really negative word, but it's just a word lawyers use. Your contract terms are really going to dictate the relationship that you're entering into, whether that be with a client, another freelancer. And you want to make sure that a lawyer is handling that, because there are also situations where you can draft incorrectly and you think those contract terms are going to dictate that relationship, but they have holes in them. And last but not least, it's usually cheaper to be proactive rather than reactive. So if you have a contract in place that protects you from the get-go, later on down the road, you hopefully won't have an issue where you have to reinterpret or rewrite and then also deal with a dispute and things like that. This last bullet point I think is super important because we do see this a lot. Proposals and emails are usually not in and of themselves strong enough to protect you like a well-drafted contract is. A lot of the time people like proposals because they're a little bit shorter. Emails are obviously very easy to shoot off, but there's kind of that trade-off of it being short and easy that's going to give you almost kind of the same type of protection, not a whole lot. So definitely recommend, in addition to a proposal, having a main contract and things like that.
Purchase orders fall into that camp too. We see a lot of people that want to rely on purchase orders, and sometimes purchase orders will have terms in them, but they're still not going to be as comprehensive as a contract. And to that point Liv made about, better to be proactive than reactive. We actually have clients that are consultants that charge a higher hourly fee to fix something that they would have charged a lower hourly fee to set up for you. We don't do that, but that's a thing.
Yeah. And so I touched on this briefly, that contracts, they can be with all kinds of people, whether that be your clients or other freelancers that you're working with. If you're working with independent contractors, those are the freelancers. A contract may help you support a claim that they are actually an independent contractor and will keep expectations clear. This second sub-bullet is really, really important though. If you've ever been on any of our other workshops, you've probably heard us talk about this, but there is a part of California law that we kind of refer to collectively as AB 5. It's all about classifying independent contractors. And there really is a pretty robust legal structure for classifying somebody as an independent contractor. You don't just get to write a contract and say somebody is an independent contractor. They have to fit into certain legal frameworks to be able to be classified in that way. And if they're misclassified, you run the risk of potentially being penalized, because you could be penalized for things like not paying for that worker's employment taxes, not having workers' comp, things like that, because if they're not independent contractors, they're probably an employee. And there's a whole lot of stuff that comes with that. So what does all of that mean? It just means another reason to talk to a lawyer. If you're going to be working with people that you are kind of thinking are independent contractors, you want to confirm that with a lawyer before you really go out and make that leap. On the flip side of that, if you're working with employees, there are also different types of contracts that you want to have in place. At a bare minimum, we recommend something called an offer letter and a job description in a lot of situations. And it's a little bit shorter than kind of your traditional employment contract, but it does similar things. It just outlines the relationship and makes everything really clear. We also encourage a lot of the time an employee handbook. Depending on your industry, an NDA might be wise, but as Sam said at the beginning in the disclaimer, everybody's situation is different. This is a situation where you want to talk to somebody about who you're bringing on, talk to an attorney about who you're bringing on to figure out what's right for you. There's also other paperwork that's required that are not contracts, but it's paperwork. So just keep in mind that there's the I-9, the W-4. Those are all those forms we've all probably filled out as we start a job, verifying different things, providing information for taxes, stuff like that. And then there's also a form that you have to file with the EDD. The EDD is California's kind of employment regulation body. It's the Employment Development Department. And so every time you hire a new employee, you have to file a form with them. So that's me wrapping up kind of the different paperwork that you would want to have in place as you bring people on to work with you. The second line of defense is insurance. And insurance is important because it's going to cover you where contracts can't or where they aren't strong enough on their own. And there are lots of different types of insurance, depending on what you're doing. Different policies might fit for you. So this is something that while you probably want to talk to an attorney for just like a high level understanding, usually an attorney is going to refer you out to either an attorney that specializes in insurance in general, or to, an insurance carrier, provider, benefits administrator, things like that. And then one form of insurance that everybody needs if they have employees is workers' comp insurance. So as soon as you have one employee in the state of California, you need workers' comp. And workers' comp, if you aren't aware of what that is, it's just a type of insurance that covers your employees in case they're hurt on the job. And so workers' comp is pretty easy to get in California. It's actually our oldest insurance program in the state, fun fact. And you can either get that through a private carrier. We get ours through the same people that handle our payroll. They handle everything for us. Or the state has its own workers' comp fund that you can be a part of. So you've got a lot of options there, but it is I think that might be the only, no, I guess your car insurance. I was going to say the only kind of insurance you need. It's one of the types of insurances you need. If you are having an employee, you need it.
Thanks for that, Liv. That was a good lead up to what's kind of the bulk of what we're going to talk about today. And I think I'll just kind of reiterate where we started with this, which is we were talking about the 3 lines of defense. And so you guys kind of get why we frame it that way and why we sort of saved these types of entities for last is because, starting with the contract, you should have one of those in place with literally anyone that services or money is going to exchange hands. And so Liv did a great job providing a couple of examples of contractors, employees. Those are great examples. But you also would want to have a contract in place with your attorneys, for instance, if you were working with attorneys, or your CPA, or really, somebody designing something for you for your website, or anybody that you're paying or you're providing services to and they're paying you, because that's where there's potential for things to go wrong, and a contract can help prevent that. Now, of course, if someone says, I don't care about the contract, you breached it, or something along those lines, people are pretty irreverent these days, maybe more than ever. And the second line of defense then becomes that insurance policy that hopefully steps in to cover whatever the scenario is. And as Liv mentioned, there's a ton of different types of policies. And for you all out there that are artists, there's going to be different types of policies applicable. For instance, if you have an actual storefront for whatever it is maybe that you create, if you make products or sell your art, you're going to want to have some kind of commercial liability policy that covers if somebody slips and falls in the store. But then sort of differently, if you're a filmmaker, and you want to get that film distributed, you probably need E&O insurance, errors and omissions insurance. And so these are all just examples of ways that ultimately those 3 lines of defense defend you, meaning your personal liability, against any liability that comes up. And, personal liability means your home, your car, your personal bank account. Those things would be subject to liability from the business if you don't have one or all or some of these lines of defense in place. So that's another long lead up to the entity, the third line of defense. And the reason it's third is it's essentially a backstop for all of this, because the entity itself, if you're following things called your corporate formalities, which I'll get to in a second, that's what's going to protect you personally from liability out of doing business. And so what am I talking about when I'm talking about these entities? So there's a couple of types of ways to do business that don't have an entity. They're informal ways of doing business. And that means that you're not required to file anything with the state. But on the flip side, you don't have that liability protection that I was just talking about. And so that's going to be your sole proprietorship. That's when you're doing business just as an individual. Maybe you have a business license or you get a DBA or something, but you don't have an LLC or a corporation. You could be personally liable for what you're doing. A general partnership, another informal one that does have personal liability, but that one's with 1+ people. So it's 2 people or more. You're partnering up, general partnership. And then the next ones that we'll talk about are the ones that you actually do file with the state. And so with those ones, I'm talking about corporations, the standard corporation that you would have if you file as a C Corp, and then limited liability companies. By and large, if you're a single owner and you're not partnering with someone else, a lot of the time for artists and creative freelancers, LLC is what we're going to recommend. And you'll see a little bit as to why as I get into the structure of these things in the next few slides. Before I get there though, not to confuse things here or anything, but there are other types of entities that you may have heard of before that I haven't covered here, like an S-Corp or a benefit corporation or a professional corporation. So we are a better professional corporation. That professional corporation part at the end is something we are required as lawyers to have, and it is a separate type of corporation. And there are certain professions that are required to have those. And then a quick note too, benefit corporations are not always the same as a B Corp. There's a B Corp certification out there that's offered by a nonprofit organization called the B Lab. And that's actually applied to any of these types of entities that we're talking about. And it's a sort of more significant assessment and analysis that's required to get that certification. But you can file as a benefit corporation with the state without going through that assessment.
Yep. Sometimes Sam says the certified B Corp is like the certified organic sticker on fruit. And I love that example.
Yeah.
Fruit at the end of the day, it just has a sticker on it.
Exactly. Yep. If you're doing good, you're doing good. But nowadays, it's also helpful to have that sticker because then people recognize that you're doing good.
Exactly.
So going back to that sole proprietorship. So this is, again, when you're doing business just as an individual. So if I went out and I wanted to offer legal services without a business actually in place, I would be acting as a sole proprietor. And with that, again, no personal liability protection, which is certainly going to be a situation where having good contracts and having insurance is very helpful. But then there are a few other things that you still need to do as a sole proprietor. One of those is going to be a business license. So, anywhere you do business, almost anywhere, some places don't require this, but most do. And it's usually going to be your county or the city that you're in. And a business license, you can think of it almost like a driver's license, because I can go out and start offering legal services and doing business without getting that business license, just like I can go hop in a car and go drive without a driver's license. But if you get caught, you're going to get in trouble. And so a business license is very similar for your local county or municipality to track and make sure that you're paying some fees and that you're doing business as you should be. And then in addition to that, sometimes you'll need a seller's permit if you're selling tangible goods. So most of the time, if you're only selling things digitally, you won't need that seller's permit. And the seller's permit's actually free to get. You just have to report and pay sales tax under it after you get it. And then last couple things on the sole proprietorship, I would recommend getting a DBA, also known as a fictitious business name, an FBN. That would allow you to do business with a name that's not your name. So if I went out to do business as Sam Mazzeo, but I wanted to call myself Better, but I didn't have an entity in place, I would need a DBA to call myself Better. And really that means that people can write checks to that and you can have it on your bank account and things like that. Last point here, it's good to have an EIN if you're doing business, even as a sole proprietor, because if you don't, you're going to be using your social security number. And that means you're going to be sharing that with people. And then it's going to be out, even Fax, I think it was, couldn't even protect people's data and they got hacked. So if you can avoid putting your social out there, good to do it. Moving to general partnerships, which a lot of this is going to be the same as the sole proprietorship. But as I mentioned, it's when there's two people or more. So not just one. And again, here, in a general partnership, both of the partners are going to be personally liable if something were to happen that they get sued for and there's found to be liability there. And then again, you'll need a business license. The good thing here is that each of the partners, or if it's three or more, all of the partners don't need their own business license. You can get it in the name of the partnership and then it'll cover everyone. Same goes for a seller's permit for the sale of tangible goods. And if it's going to be all for the partnership, not just for an individual. And then again here, DBA, if you're going to call the partnership something other than your names, you'll want a DBA or fictitious business name. And then an EIN, again, is a smart thing to have so that one of you guys or all of you are not using your social security number. And the other sort of difference that you'll see in that bottom note there is that with a partnership, obviously as a sole proprietorship, you don't need an agreement with yourself, but as a partnership, you do need an agreement with that other person because well-drafted contracts will protect you.
And just to point out one little thing here. So obviously when you're a sole proprietor, you can assess your risk and make sure that you're not getting into trouble or try to not get into trouble. With general partnerships, you have to remember that the other person can get you into trouble, even if you're not part of it. So if Sam and I were partners and I don't know, I did something fraudulent or I embezzled money or something like that, and Sam, even if Sam had no awareness of it, Sam gets pulled in. And so that's really important to think about too when we're thinking about no personal liability protection. You really have to trust the person you're going into business with.
And you can try to contract around some of that in that partnership agreement, which is, again, why that's so important for sure. Not everything, though. All right, let's move into the big boys here. So this is kind of when you're playing in the big leagues, when you have a corporation or an LLC in place. And the reason I put it that way is because, again, these will provide you with that personal liability protection. And as I'd mentioned before, that comes with trade-offs. That means that there's more to do, meaning there's more to file, there's more to pay, there's more to essentially do on maintenance of this every year. And so this is kind of like the OG business entity out there. It's the original one, with the exception of trusts. We'll give you another little fun fact. The reason there's such thing as antitrust laws is that way back in the day, all businesses were done with trusts. And so when a trust got too big and basically took over the marketplace, that is when antitrust laws came to be. Then someone came up with a corporation later on. Corporation really stuck. And the LLC is actually relatively new in the terms of law, which means like a few decades. And so the corporation, it is the more complex of the two when we're talking corporation LLC. And the reason for that is partly because anytime you give lawyers a long time to monkey with something, they're going to make a mess of it. And so lawyers have been around messing with corporations for a long time. And so they're very much more involved than your LLC, and certainly those informal ways of doing business that I mentioned. So here, the big thing though, is that you do have personal liability protection. Now, similarly here, it's anytime you're doing business, you need that business license. Again, here though, like with the partnership, that business license would be for the corporation. So you could have, 100 shareholders in your corporation, just need one business license. And then the cool thing with a corporation or an LLC is that with those, you actually probably don't need a DBA or a fictitious business name. And the reason for that is that if the corporation is the name that you're going to be using publicly, then you don't need a DBA because a corporation doesn't have to be named after you. And so the only time you need a DBA for your corporation is if you go out and you use different names than the official name of your corporation. So an example that's kind of confusing. An example, we again are a Better Professional Corporation. It's a mouthful. We don't use it every time. We go by Better. And we had to get a DBA for Better because it's not our full official name. And again, the benefits there are people can write checks, or we can have that with our bank account and things like that. And then you're legally compliant, of course, as well. And so an EIN, again, you'll want that rather than using someone's social security number for the corporation. And you can just really think of an EIN as the social security number for your business. Moving on to more corporation stuff. So one of the things that I kind of like to dispel the myth around is that a lot of people, you'll hear them say, oh, I have a
Delaware
SCorp. And the whole notion there is sort of a traditional approach to Delaware is where you should have your company. And there are reasons for that. Now, they're not usually applicable to the vast majority of people, however. And the reason for that is that most of the benefits that you get with a Delaware company are only applicable if you live in Delaware. And I will tell you, in almost 10 years of practicing law and forming companies, I don't think anybody actually lives in Delaware. I think companies are just formed in Delaware. So you're probably not going to get any of those benefits. I know people live there. I'm being facetious. But the whole idea of that is problematic because if you register in Delaware first, but you're in, let's say, California, you're a resident there, and that means you file taxes and you report your income from that Delaware company. And sooner or later, California is going to say, well, you need to register that company here because you're doing business here, you're reporting income here. And as a government, we make money when you do, and we want some money from that company. So if you register in Delaware and you're in another state, you're actually probably going to ultimately double up on annual requirements, taxes, fees. And so that's why I call it a myth. Sometimes it's beneficial. There's one other sort of thing that it benefits investors. If you have investors in your company, which are probably not terribly applicable to a lot of people here, but something to mention. And that's why I think of that as a little bit of a myth. Now, some of the things to talk about with a corporation. So the structure of a corporation can be confusing, and it can be very sort of cumbersome for if it's just one owner or even two owners. because the way that a corporation works is the owners are called shareholders, and they exist at the top. And what they do is they have a certain number of shares that equates to a percentage of the ownership of the company. And then they actually appoint the board of directors. And the board of directors is who usually makes most of the decisions and actually instructs the officers of the company, the next level down, to carry out the decisions that the board made. And so if it's a 1 or 2 person company, you could see where there's going to be shareholders, and they're also the board, and they're also the officers. And that's a little bit silly because you're actually required to hold shareholder meetings, board meetings annually. So corporation, not the best for a couple people or a small company, which is why we typically recommend LLC, like I'd mentioned earlier. And then one of the other things about a corporation to mention is that it's actually a separate tax status and tax filing, whereas sole proprietor, general partnership, you would just report your income and pay it on your personal taxes. Corporations are going to have separate tax filings that are not part of your personal that you file for the corporation on a quarterly or annual basis. So moving on to limited liability companies. This is the one that pretty much is what we recommend most often. And like I mentioned before, a little bit newer, but the important things about an LLC are going to be, again, personal liability protection. You get that with your LLC. Again, business license. You'll need that in your city or county. And then seller's permit. You'll need that if you're selling tangible goods. Again, don't need a DBA if you're doing business publicly with the name that the LLC was filed with. And then you'll need an EIN again for this type of entity, which you're starting to see here that the through lines are you always need a business license, you may always need your seller's permit, and you pretty much always need an EIN. And so those are going to be true of any way you do business. And again, with how you get protection from having one of these in place, your corporation or your LLC, it's by observing those corporate formalities. So here we go with LLC structure, which, I was talking about how complicated a corporate structure is, and to sort of see why it's helpful to understand the LLC structure. Now, with LLCs, there's no shareholders, there's no board of directors, there are members, and the members are the owners. And then the members can also be the managers. So essentially, you can have all of that decision-making and action focused in one or a few people that are everything. And LLCs are great because you actually don't have to hold annual meetings like you're required to with a corporation. So the other thing that's important to mention here is something that gets really confusing for people with regard to how you should refer to your business and the tax status of it. Because even before I mentioned, sometimes, Delaware SCorp. Well, an SCorp is actually not a type of company, and we'll talk about that in a second as well. But an SCorp is a tax election. And so as an LLC, you can actually elect to be treated as a C Corp or an SCorp, or if you just stick with the normal default treatment for your LLC, it's going to be the same if you're a single owner LLC as a sole proprietor. Or if you're more than one owners, it'll be treated as a partnership for taxes. And the reason for that is that an LLC is considered a disregarded entity for tax purposes. And super confusing, but the best way to think of it as the state gives you the entity itself, the LLC, the corporation, the professional corporation, but then your tax status can be altered and it doesn't change that underlying state given type of entity. And like I said, we'll get into that a little bit more in a second. But the last thing to kind of mention here is that the reason LLC owners are called members instead of shareholders like a corporation is that you have a membership interest in an LLC. And that's why in a corporation you have shares, shareholders, membership interest, members. So the corporate formalities, I keep talking about those and you're saying, what the hell is that? So corporate formalities are a set of tasks, actions, obligations, filings, payments that you have to be mindful of. This is not a comprehensive list by any means, but these are a few examples that I think help drive the point home, because at the end of the day, observing your corporate formalities preserves and protects piercing the corporate veil, which the corporate veil is what protects you personally, your personal liability. And piercing that corporate veil is getting to you for personal liability rather than holding the company liable. And in order to preserve that corporate veil and prevent it being pierced and prevent being personally liable, you have to observe your corporate formalities. Now, you've heard of some of these probably, which keeping a separate business bank account versus your personal bank account, that's certainly a big one. Don't start commingling and paying bills for you or the company or the other way around. That'll blur the lines of personal versus company. And then making sure you're filing with the state, paying your tax. In California, there's an often forgot about tax called the California minimum franchise tax. If you don't pay that, definitely one of the corporate formalities could be something that hurts your ability to enjoy that personal liability protection. And then another thing that people sometimes don't do is going to be having your internal governance paperwork in place and signed, which for an LLC is an operating agreement. It's essentially the equivalent of a partnership agreement if there's more than one person in that LLC. And then a shareholder agreement and bylaws for a corporation. Bylaws typically dictate what goes on with the board of directors. Shareholder agreement, you guessed it, for the shareholders. And those are also considered corporate formalities. And then, of course, one of the things that I think is never really paid much attention to, but is really important, is making sure that when you sign paperwork and you have a company, that you actually sign with your title, whether it be president or secretary or even shareholder or member or manager. Because if you don't, you could actually ultimately be found to be personally liable, because you could be found to have signed that contract personally. And there's actually a pretty famous example of this. It's a very orange gentleman that used to run a country, and he sells steaks and fake college tuitions and things like that. And he used to sign things with his name without his title. And he got in a bunch of trouble for that, as he tends to do. And yeah, that note at the bottom there, certainly important to mention that LLCs have these corporate formalities too, even though they're called corporate formalities. That's why I mentioned the operating agreement. And so these certainly apply for both your LLC or your corporation, or a professional corporation or a benefit corporation, all of them.
Corporate formalities are kind of just like saying you can't have your cake and eat it too. You can't expect to be protected from personal liability and then go and use it as your personal piggy bank, or not treat it like it's a very serious thing. That's sometimes how I think of it.
The whole don't treat your company as a personal piggy bank. You should think of it as separate. It's, in the eyes of the law, it's its own person, actually. So your corporation, your LLC, because it has its own EIN. All right. So I had mentioned before, you hear people say, oh, I have an SCorp. I have a Delaware SCorp. So again, an SCorp's not a type of business entity, is actually going to be a tax election. And that means that you can be a corporation with an SCorp election. You can be an LLC with an SCorp election. You can be a benefit corporation with an SCorp election. It is something that typically, depending on your revenue, is very favorable for you to choose to be.
It gives
you more write-offs and better sort of tax situations than you would have if you were going to be just a LLC or a corporation. So we covered corporate formalities, and then I was just talking SCorp. With the SCorp, just to wrap that one up, again, only a tax election, not an actual type of company. And the really important thing there is, what I always tell people is, I think it is much, much easier and always a good plan to talk to a CPA about any recommendations that you get from an attorney, because it is much, much easier to fit the legal strategy to the tax strategy rather than try to do it the other way around. Because at the end of the day, and actually a better way to put it, is at the end of the year, it all comes back down to taxes. That's the backstop to all of what you do during that year. And so if you end up setting yourself up legally, but it didn't have any tax planning involved, you could end up paying some taxes and having some things that you didn't expect that you could have avoided had you maybe spoken to a CPA and done the SCorp election, for instance. And so it's a very helpful thing. And certainly for LLCs, we, by pretty much across the board, by and large, see that LLCs benefit from that SCorp election. But again, we are not tax attorneys or CPAs, which is why we recommend that if we're conversation 1A, conversation 1B should be with that CPA. So with this question, when should I form my LLC or corporation? We get this question maybe more than any other question that we get. And we get a lot of questions a lot of the time and over. And this one is one of them that we get a lot. And it's a really hard question for us to answer for a bunch of reasons. And here are some of them. For instance, is the juice worth the squeeze on the costs? It's not free to set up an LLC. You're going to pay us some money to do all of these filings and all of that internal paperwork that we've talked about today. So, shareholder agreement, operating agreement, state filings, local filings. And then in addition to that, there's the California minimum franchise tax that I had mentioned before, which is a minimum of $800, and it actually goes up based on your revenue. And that is due even if the company is not generating revenue. So the California minimum franchise tax and the costs to set up your LLC or corporation are really what you want to look at. And then another reason to talk to that CPA is you can talk to the CPA and they might be able to say, look, you're actually going to save, $3,000 in taxes this year with your LLC or corporation, which might actually take completely the cost to set it up and that minimum franchise tax, and you still come out on top. So tax savings sometimes can be really what makes it worth it to do this and take this step. Now, another type of thing is going to be how risky is it the business that you're doing? I sometimes think that there are some creative industries that aren't terribly risky, but in reality, a lot of them are pretty risky, and maybe more so than you might think, because there's a lot of people out there that troll with regard to trademarks and copyright, whether it's images or content. And then in addition to that, if you're doing anything that shows other people, or if you're actually repurposing someone else's work and trying to make derivatives of that by putting it in a new medium or remixing it or something like that, there's potential that the original artist may take issue with that. And so it can actually be kind of risky. Now, not as risky probably as like an axe throwing rink or something like that. That's a different type of risk and certainly a substantial one. But the risk profile of what you're doing certainly can be a motivation to get one of these entities for that personal liability protection. And then
maybe your business is just in the
super early stages, and the money just might not be worth it for them to form that LLC that early. And if you're not planning on running it for a long time, it might not also make sense to pay all these fees, do all these things, do all these filings, because you're just going to have to undo it later. And so sometimes temporary businesses might not be the best idea to form the entity. But, as attorneys with our lawyer hats on, we're basically always going to say to do it because you get that personal liability protection. So it's something that we would recommend, most of the time, unless some of these factors I mentioned just really weigh against it.
Yeah, definitely. When you were mentioning how risky is your business, I was trying to think if there's a business we could use as a very, very low risk example. And I couldn't think of a single one. It's just all different types of risk.
Right. I think maybe consulting, but even then, consulting is something where if someone hears you wrong or they act on what you say, they think you're liable, which, that's similar for us as lawyers. So yeah, there's not really a whole lot of low risk things out there anymore.
Yeah, unfortunately. All right, so we're to the questions portion. As a sole proprietorship, does a business license, DBA, seller's permit, and EIN require annual renewals?
Yeah, so pretty much everything, unfortunately, requires renewal. So a DBA typically is going to be a 5-year period of time that you have it, and then you need to renew it after that 5-year period. And one funky thing to mention on DBAs that I didn't mention before, typically once you file for one, you have to actually publish it in a newspaper for like a period of weeks. It's a weird old thing. And so that's something to mention. But then business licenses, I believe, was part of the question as well. You do have to renew those as well. Those are going to be an annual renewal. And the funky thing with business licenses as well is that we typically apply for the business license for people. And then once we apply, the office sends a notice to the client's business address, and there's an additional fee that has to be paid, which is actually calculated based on which neighborhood or district you're in your city or county. But again, those are renewed annually. And then a seller's permit doesn't require renewal whatsoever. You just have to make sure you're reporting and paying sales tax on the products you've sold.
As someone selling an art piece, if I'm set up with a business license, am I supposed to charge sales tax?
Yeah, so anytime you're selling an art piece, again, if it's a physical one, not, like what's the new thing, NFTs, those are digital. But if you're selling a physical art piece, sculpture, painting, something like that, even if you're selling a photo that's framed, you would need to charge sales tax on that, and you would need a seller's permit to sell that. A business license is a totally distinct and separate filing from the seller's permit, and they don't actually really relate to each other very much, other than you have to have both.
What if we want to start by trying to make some art sales via the internet? How much liability would that have? The internet is a vast place, and there are actually laws in place that regulate how the internet can be used for all kinds of things, including sales and collecting information and things like that. So if you were going to try to sell things on the internet, it would really depend on what avenues you're using. Are you using Etsy? Because if you're using Etsy, you probably don't need as many of the documents in place that we would recommend if you have your own personal website, because Etsy is in charge of covering that stuff. And so what I'm mostly speaking about, you'll sometimes see on the bottom of websites where they'll say like privacy policy, and then they'll say terms of use, or maybe sometimes terms of service. That privacy policy is actually a legal requirement. And so it's required when you're collecting information from people, and some of the triggering information that you would need to collect to then fall under that law that requires the privacy policy is just as simple as a name and an email address. So if you're selling by the internet, you're probably collecting that because you need to send your art somewhere, right? So bringing it back to the Etsy example, Etsy is in charge of having their own privacy policy in place. They cover you as an umbrella. So when you sell through their website, you're good to go as far as privacy policy goes, because theirs is what's covering you. If you have your own website, however, it's up to you to make sure you have that in place and you're in compliance. It does get a little bit tricky because, as we all kind of have learned, the internet doesn't really have any borders, but countries still think that they can enforce borders on the internet. So if you're selling to people, you really need to be clear about who you're willing to sell to. If you're selling to people outside of the US, international laws are going to apply, and they get really complicated really quick. So you definitely want to talk to an attorney about your specific situation.
I would just add to that, to kind of like round that one out, is that I would also encourage people, watching this, to sort of think of liability and doing business less about the way it's delivered, like the vehicle, so internet or brick and mortar or a farmer's market or a craft
fair, each
is going to have its own type of risk. And so even just selling over the internet, similarly going to have potential issues there.
Kind of tying all of that back to the liability question of why the privacy policy even matters. If you don't have that in place, you can be liable for not complying with the law, but data privacy breaches, Sam mentioned earlier, the Equifax stuff, all of that is like a whole different world of liability that you have to be aware of. So if you're like collecting credit card numbers, people's emails, their names even, you're potentially putting yourself into data privacy liability world, which is huge. Is sales tax due on a screenplay option?
How about on live performances?
So sales tax on a screenplay option, no. That's going to be, I'm trying to think of the best way to characterize this, but that wouldn't be something that triggers the sales tax, because again, it's going to be tangible goods. And I will add a little bit of an asterisk here that the landscape of sales tax laws are changing. And there are some places that do now charge sales tax on digital goods. And so this is another reason, I guess, just another nod for speaking to a lawyer for things like this, because that's another thing that you might not know, is that the law changes frequently. And so, with sales tax changing a lot, just like AB5 and the employment law is changing a lot, we are required as attorneys to stay up on that stuff, and we can help advise on it. And so my answer off the top of my head for the screenplay option is going to be a no sales tax due on that. And then sales tax on performances, similarly, I'm going to go with no there, because again, it's not a tangible object, even though you may, a screenplay option may have paper, the actual screenplay itself, and then, a performance might have tickets. Those aren't the tangible good that's being sold. So based on that rubric, and assuming that that hasn't changed in California or any of the places you may be viewing this from, I'm going to go with no on that one as well. Now, of course, as we mentioned before, and I certainly don't want to sound salesy, but if we do a consultation with folks, we have more bandwidth to look into these things more specifically for you and kind of go down that rabbit hole. But I'm going to go with no on both of those for right now.
If you collected names/emails on your website for a followers or a mailing list, do you need a privacy policy? It's a great question. Yes, that's usually the first thing I look for on a website, because that's a very easy way to just check that box of yes, you need a privacy policy. If you are collecting names and emails on a website, definitely look into privacy policies and speak to an attorney. There are a ton of privacy policy generators out there. And I have to say, I've seen so many of them, and they're almost always outdated law. They don't protect you at all. So definitely speak to an attorney. Is a bar, club, or restaurant considered a public accommodation, and is a model release needed from someone if a picture of them is taken in that kind of setting?
Does the answer change if the person is famous or not famous?
Yes. So public accommodation for sure, if it's publicly accessible, and we have pretty specific vocabulary as lawyers. And so public accommodation to me means, is it a place that the public can access? And so that's something that's usually relevant for like ADA accessibility, things like that. But also in this question, totally a restaurant is a public place. And as far as a model release goes, you would actually need to get someone's permission to take a photo of them and then use that photo, even if it's just going to be hung up in that bar. Now, I know there's a lot of people out there probably rolling their eyes going, but there's all these places in these bars that they take photos of someone and they put them on the wall. And you could maybe argue that there's sort of a implicit and inherent sort of consent from that person if they see that there's a wall of photos and you take a photo of them to put on that wall of photos. Certainly not as ironclad as an actual appearance release or waiver that they sign. But the crux of this question is, if you take a photo of someone inside one of those places, bar, restaurant, club, and then you hang it up in there, do you need permission for that? Should you get a release from them? Yes. And the question also sort of clarifies if they're not famous or if they're famous. And as someone that's not famous, it's actually even more important that you get that release from them, because as people that aren't famous, as non-public figures, we actually do have an expectation of privacy, and we actually do have a right to control how our appearance and likeness is used, as opposed to a public figure who doesn't have that right. They have no right of privacy. Their image and likeness can be used pretty much however you want, as long as it's not derogatory, slander, or libelous. And the way that my law school professor put it is, once you're in that public vortex, you're essentially just subject to whatever that public vortex does to you. And, you know, if he used to call them vortex thrusters. So if you're a public figure and you've thrust yourself into that vortex, you're essentially, you don't have those rights anymore. So even more important to get that release from someone that's not famous, even if it's just going to be to hang it up in that restaurant.
Can that image be exhibited or published inside a gallery show, not the restaurant or the club?
That sort of just double confirms that you need their permission, because then the way that my sort of lawyer brain thinks of this is that you're then using that person's appearance or likeness for a commercial purpose. And certainly anytime you use someone's image to make any money or for a commercial purpose, you'll need their permission and a waiver or release that you're allowed to use their image. You know, I mentioned before documentary films and how they have E&O insurance. We actually screen documentary films to make sure that they're not going to get sued. And one of the things that we have to tell people pretty often is, yeah, that person that you can see right behind the subject of the filming, that you can see their face clearly, you need to blur them if you don't have a waiver or release for their appearance. And so certainly, yeah, if you're going to then have it in art that you hang up, you know, and I also always like to acknowledge, like, that may not be what you hear from other artists that take photos and hang them in their gallery because they've never gotten in trouble. But, and I hate to say this because it sounds like, you know, your parents when you're growing up, but like, if everyone jumps off a cliff, are you going to do it too? And it's one of those scenarios where just because someone didn't get in trouble doesn't necessarily mean that they were compliant, unfortunately.
Yeah, or it's kind of like what we were talking about at the very beginning of contracts, that you don't know what you don't know. That person just might not even understand what they're doing and what they need to be doing.
Right. And people may not know that they're hung up in that gallery. And then if one of the, you know, images sells for a bunch of money and they see it somewhere, or there's some press on it, then they also are going to look at that and go, ooh, deep pockets. And I didn't give permission for that. I'm going to sue them.
Yep. Where can I get an image release? I think you might have an idea of what our answer is going to be here, but you can get it from an attorney.
These guys.
The cool thing about image releases is, generally speaking, if you're doing the same kind of thing over and over and over again, that's something that we work on once, and it can be templatized. I don't usually love saying that word because people do tend to run wild with them and think, yes, I can use them in every situation. But, you know, like I said, if it's really the same sort of thing over and over again, that might be a situation where you can use it over and over. I will need to try to trademark a business name. Can you give an estimate on how much that might cost from start to finish?
Absolutely. So we always recommend that you run a comprehensive trademark search first. And the reason for that is that, you know, we're all, even just non-lawyers, are capable of going on the internet, searching the name, trying to search the USPTO database. It's called TESS. It's the Trademark Electronic Search System. And people use that. And those searches are great. They're a great, what we call a knockout search, because if there are similar marks out there and you do those searches kind of on your own, it's going to be pretty quick to see how many other similar marks are out there. And then that'll knock out that mark for doing further research on it, which would be that comprehensive search, which is much, much more, like the name says, comprehensive, and gives us a wealth of information that then we, as attorneys, review and comb through, and then we provide determinations of what we think your likelihood of success for applying for trademark registration will be. And the whole point there being, if you actually just go out and file a trademark application, it can be pretty expensive, and I'll get to those costs here in a second. And if you throw all that money at that application, but you could have already found out from a search that it wasn't going to succeed, then you're going to save a whole bunch of money on that application. And more importantly, if you file a trademark application and there are similar trademarks out there and they monitor the trademark applications, you could receive a cease and desist letter in the mail because they see that you're applying to register what they already have registered. So the costs, our comprehensive search for a word mark is a $200 flat fee, comes with a PDF report that flags any similar marks, as well as our determinations, like I mentioned, and a 30-minute call to discuss. And then trademark applications, the USPTO charges a $350 fee per trademark class. There are 45 different trademark classes, and there's a lot of strategy that goes into which classes you should apply in and what your likelihood of success is in each class. And that's another thing that we get from the search. And so that's per class. So if you went with 2 classes, that's going to be $700 in fees. And then for us, we charge a $500 flat fee to draft and file a trademark application. And then we charge a $150 fee for each additional class. So I know that's confusing. The way it works is it's $850 for a single class application. And then it's going to be an additional $500 per additional class, all said and done. Now, start to finish, can't always answer that because sometimes the USPTO will issue an office action and require us to argue or respond or file something else, and we might have to bill hourly on that. But typically it's going to be, if you do the search and a single class application, $1,050, and then assuming there's no issues with the application, that's all it would be. And then timeline on those is usually about 6 to 8 months for a trademark application if it doesn't have any issues.
Using a photo of a face for a painting. The final image isn't an exact copy. Is there an issue? Sam, feel free to jump in, but the first couple of things that popped up to me is, did you take the photo or did somebody else take the photo? Do you have a license in place for the person you took the photo of? And then something we talk about when we are talking about copyright and things like that is how transformative is the final project. And transformative, a lot of the time people think it just means changing the medium, but sometimes it requires a lot more than that. So there's a lot going on here. Even the transformative analysis is a lot of, I think it's 4 subsections of kind of going through different considerations in 4 like broad categories. So there could be an issue. We'd have to kind of run an analysis for any copyright issues there.
Right. And the way I would frame that is that all of the things that Liv mentioned as far as a license and permission and things like that, those are all going to essentially protect you no matter what the analysis yields. But if you don't have those things in place, we could do an analysis, or a lawyer can do an analysis for you on whether or not it is a transformative enough use of that original photograph.
If I took videos of a street scene while driving and use it in a video that promotes my client's services, do I need permissions from the people that are on that street?
It'll depend on how visible the people are. You know, if you can see their faces and you can make out who they are, that's typically when that whole appearance and likeness rights will attach. In those situations, I always just say if you can blur it without it hurting the aesthetic of the video, best to do that, because you'll very much protect yourself by doing that, because then there's no risk at all. You shouldn't need permission from the street scene itself. Like if it's a market or an event or something like that, most likely you shouldn't need permission. But these questions can get very layered, because if there's trademarks visible on a banner or something like that, that might be something that could cause issues for you. If there was music playing and you keep that music in your video, there's a whole deal with music being played publicly. It's called ASCAP. And if you're not compliant with that and then you put that in the video, could be issues. So you can see where these things like intellectual property is multi-layered already. And then when you have something like that, there's layers on the layers. So I would say, you know, blur stuff that looks like someone might have rights to it. Don't keep the music in, things like that. Blur people's faces and you should be okay.
Well, thank you both so much. I think this was a really great workshop that we've been wanting to offer for a while, just because I know sometimes it's good to have like a baseline. And then I know we usually have you all cover more complex or focused issues. So thank you all so much for being so thorough and just being always so accessible with the way that you present.
Thanks everybody for tuning in too.
And for your good questions.